Hello, everyone, and welcome. Welcome. We're so glad to have you here to our part two of our segment, Protecting Our Home. And we're so pleased to have in our midst Senator Leroy Comrie. And everyone, all of you should know who he is. He's a Democratic member of the New York State Senate representing District 14. But even more than that, he just helps our community. He does a lot of stuff for especially my people, the seniors, and for community members. And I'll leave the floor open for Senator Comrie if you'd like to say a few words.
Well, thank you. I appreciate this opportunity to communicate with folks again. I want to thank Brooklyn Legal Aid for continuing to do everything they can through webinars, through meetings, through outreach, through going to events to try to get to our homeowners on a one-on-one basis. I'm proud to work with Brooklyn Legal Aid and the Legal Aid Society and NHS of Jamaica, along with the Protect Our Homes Coalition, because we have to make sure that we are safeguarding our homes. And unfortunately, in Southeast Queens, we're losing more homes to nefarious practices, to deed theft, to the lack of estate planning, to folks not being able to actually afford the homes that they purchased because they were given bad information and bad direction by their real estate or the people that they purchased the home from. And Brooklyn Legal Aid has been working to try to make all those things happen, to make sure that if you are facing foreclosure, we can help stop it. If you're deed theft, we can work on making sure that that's being taken care of, that if you're having issues with property taxes or water bills or any other bills that is affecting your ability to pay, they can help you work something out. And now tonight, they're talking about protecting your home after death, safeguarding your legacy, which is important. A lot of us don't do the pre-planning necessary to protect your legacy, to protect your home after you've passed on. And there are many things that can be done that would make sure that your family or whoever you designate would be able to utilize your home after you've passed on. So thank you, Brooklyn Legal Aid, for continuing to do these events and webinars and meetings and making sure that you're in the right place at the right time to help people. But with that, I want to pass it back to you, Sister Di. Thank you for the wonderful introduction and your faith in me. I'm going to continue to try to do whatever I can to serve my community in the best way possible. Thank you.
Thank you. Thank you so much. So again, you know that you're in the right place if you're safeguarding your legacy, protecting your home after death. And this is part two. And we're part of the Protect Our Homes Coalition, and our focus is to prevention and also to make sure that we are prevention and enforcement. It's a network of community and government partners, including New York State Attorney General, of course, Senator Comrie's office, and New York City Department of Housing Preservation and Development. And it's about anti-displacement, right? And law enforcement agencies are with us as well. Here today, you're going to have the pleasure of having Emily Lano. She's a paralegal with Brooklyn Legal Services Corp. A. And of course, we have Chris Fasano. He's a supervising attorney with the Foreclosure Prevention and Homeowner Stabilization Project. That's a mouthful, with the Legal Aid Society. And then, of course, you have me. I'm Dion Woodburn. I'm the Legal Services Supervisor of JASA Legal Services for Elder Justice. And together, we're making up the Queens Coalition. And so, again, Queens Coalition is Brooklyn Legal Services Corp. A, the Legal Aid Society, Queens Neighborhood Office, the Neighborhood Housing Services of Jamaica, and JASA Legal Services for Elder Justice. Now, I'm going to tell you a little bit about Neighborhood Housing Services of Jamaica. Now, it's a housing counseling service with counselors trained and certified by the Department of Housing and Urban Development. That's HUD. And what they do is they help you to maintain quality and affordable housing. They help you with foreclosure prevention, first-time homebuyer counseling, rehab loans and grants, resolving property taxes, landlord tenant counseling, and financial literacy education. Now, if you don't know about them, you know about them now. So get in touch with them and you're going to see that information coming up. And then I'll tell you a little bit about JASA. I'm talking a lot, but JASA is an agency that only deals with seniors. You have to be 60 and above, and we do tenant rights, foreclosures and predatory lending, real property fraud. We help with entitlements, tax deductions, tax credits. And I know we're talking about protecting our home after death. You got to have a home to protect, which is why Emily is going to talk to you all about saving your home from the tax lien foreclosure. She's going to come on. And we do health and long-term care, consumer utility law, family law, and we do elder abuse and financial exploitation. Let me have Chris tell you a little bit about the Legal Aid Society.
Thank you. So we are a nonprofit legal service provider. We provide a host of services covering a lot of the same areas as JASA. But the project that I work in is one that protects homeowners and tries to stabilize communities that are affected by eviction and displacement. So we represent people in foreclosure cases. So when people are sued in foreclosure, we'll go with them to court. And we participate in every step of the process, from doing appeals. We do federal litigation. We will advocate for people through public policy reform. And that's kind of the core to our mission. So thank you for joining us tonight. We look forward to talking about how to protect your home after death.
And Emily's going to tell us a little bit about Brooklyn Legal Services Corporation A.
Yes, thank you so much, Deanne, for the intro, and thank you all for being here. So Brooklyn Legal Services Corporation A, also known as Brooklyn A or BKA, is a wonderful organization that similarly provides legal representation and advocacy, including full representation, advice, outreach, and education to low and moderate income individuals and families. We also support community-based organizations through one of our practice areas, and we also do community development corporations, coalitions, and small business owners work throughout the city. And we are also, advocating for protecting housing of everyday New Yorkers, providing access to education and healthcare, and safeguards, and safeguarding subsistence income for our city's most vulnerable residents. We also represent homeowners facing foreclosure, and we defend homeowners against predatory lending and represent taxpayers who have issues with the IRS through our low-income taxpayer clinic. So with that, I think we are going to jump right in. So as Deanne mentioned, will be starting by just talking a little bit about the upcoming tax lien sale. And as Deanne said, if you don't have a home to protect, this whole presentation becomes less relevant. So we want to make sure that you can keep your home. And a really important part of that is making sure that you are not in the upcoming tax lien sale. So what is the upcoming tax lien sale? Essentially, if you owe any property tax charges or water and sewer bills over a certain amount, the city may sell your debt to a private company through what is called a tax lien sale. This is coming up in almost exactly a week, I guess just under a week, on May 20th of this year. And so once your debt is sold, the reason this is really a high concern is that once the debt is sold, the company that buys your debt can add really high surcharges and interest rates on top of what you already owe, resulting in your arrears increasing, extensively, and increasing your likelihood of foreclosure. So we really, really want to emphasize the importance of making sure that you are not in the upcoming tax lien sale and acting essentially immediately because the timeline is rather short now. So I will be covering that, beginning with what might result what might cause you to be in the upcoming tax lien sale. So as I mentioned, if you owe property taxes, water and sewer charges, including surcharges, if you owe emergency repair and alternative enforcement charges, or if you owe interest, fines, or fees on the taxes and charges I just listed above, or if you're an owner in a delinquent payment plan and have not made payments for 6 months, you might also be in the tax lien sale. And lastly, if you have a Housing Development Fund Corporation or an HDFC rental property with $5,000 of unpaid charges for over 2 years, you might also be in the tax lien sale. So to figure out definitively if you are in the tax lien sale, you should first and foremost check your mail. Everyone that's in the tax lien sale, the Department of Finance is required to send them a notice to their address that is in the sale 90, 60, 30, and 10 days before the upcoming date, which is in a week. So you should have received several notices at this point. And even if you have not received those notices, if you know that you have arrears or dues, please be sure to also check the online website, because it's possible that those mailed notices might not have reached you. So in that case, we highly recommend that you check this online website, and we will be circulating this deck afterwards for you to click into these links, or you can call the Department of Finance in the event that accessing this website is not an option for you. So we highly recommend that you reach out and determine if your property is in the sale immediately. Next, we are going to go over 4 options. I apologize for these numbers here. 4 options for how to get your property out of the lien sale. So beginning with entering into a payment plan. We can go to the next slide if you don't mind. You can enter into a payment plan. You can enter into a standard payment plan where you're charged a basic interest rate, and the eligibility criteria for that is pretty expansive. And in the event that you qualify for PT-8, that is another payment plan that you can apply for. And this has specific criteria that allows you to be eligible for it. So PT-8 is a property tax and interest deferral payment plan, and you're only eligible if you own a 1, 2, or 3 family home or condo unit, if the property has been your primary address for over a year, if all homeowners earn less than $107,300 annually, and if you have fallen behind or in danger of falling behind on your property taxes. So that is the eligibility criteria for PT-8. We also have a PT-8 circuit breaker plan that has slightly different criteria than those mentioned on the previous slide. You do have to meet all of the criteria listed on the previous slide. And in addition to that, if your property tax bill is more than 10% of your income, you might be eligible for this payment plan, or in addition to that, your property must have an assessed value of $250,000 or less. And basically, these allow you to enter into payment plans that have lower interest rates and are more accessible to folks who might be lower income and don't have access to paying off the payment plans in large sums. So second, you can apply for a property tax exemption. There are 3 kinds of these exemptions, and this is specifically for particular demographics that we'll go through. It's very important to note that the deadlines on the forms to apply for these 3 exemptions say that the deadline has passed in March. However, rest assured that you can still apply to these programs. The distinction here is that the property tax exemptions themselves that are associated with these exemptions will not go into effect until next year. However, if you're approved for these various exemptions, it will get you off of the upcoming tax lien sale this year. So you can get off the tax lien sale this year using these exemptions, but the tax exemptions themselves will not go into effect next year. And I'm happy to answer questions about that, because I know it's a little bit confusing. So next I'll go over the 3 different exemptions at a very high level, just as far as eligibility criteria go. For the senior citizen homeowners exemption, SCHE, you must, or I guess all owners must be above 65 years of age or older. For the disabled homeowners exemption, all owners must be folks with disabilities. And for the veterans exemptions, we recommend visiting the lien sale website for eligibility requirements, because they are a little bit more specific. So we've hyperlinked the website to that exemption here. And it's very important to note that for all of these 3 exemptions, there must be a combined annual income of $58,399 or less among all owners. And also the property must be the primary residence for all owners as well. So these are the eligibility criteria. If you think you might be eligible, again, please act soon. We're happy to help. That's what this call is all about. So moving on to the third exemption for the upcoming lien sale. This is the exemption that Brooklyn A has been seeing, I would say most regularly, which is the Lien Sale Easy Exit Program application. It is fairly straightforward. In order to be eligible, you must own a 1, 2, or 3 family home or condo unit. The property must be your primary residence for at least 1 year. And you cannot own any other property in New York City. And the combined annual income of all owners, regardless of whether they reside at the property or not, cannot be greater than $107,300. And it's important to note that LLCs and corporations are unfortunately not eligible for this exemption at this time. However, trusts are eligible, and this is a very new development that a policy development that went into effect, I believe, 2 weeks ago at this point. So you are in luck if you have a trust, you might be eligible for the Easy Exit Program application. And then at a very high level, I'll just go through the process for applying for this. You must request the link to an application if you submit virtually, and you will be sent an application within 2 to 3 minutes. It's a very quick turnaround time. Definitely check your spam inboxes, because they have been known to make their way into those inboxes. So rest assured that they should be in your inbox somewhere. Just be sure to check around. You do have to complete the application, which requires some documentation of either federal tax returns and state tax returns. And if you don't have those, again, it is okay, but you do have to provide proof of income if you don't have available tax returns. And lastly, you'll receive confirmation that your application was received once you submit it, and you'll have a response likely within 30 days. And we've been seeing responses happen a lot sooner, especially for those that have been submitted virtually. There are also paper applications that you can mail in if you so choose. And for the fourth exemption from the upcoming lien sale, this is the emergency repair certification that you can submit to get out of the lien sale. So if you owe housing prevention and development emergency repair charges, you may be eligible to be removed from the lien sale for 1 year if the property is a 1, 2, or 3 family residential property in tax class 1, and if you're the owner of the property and it's your primary residence. So moving forward, I just briefly want to touch on the deadline for submitting exemptions. I really cannot emphasize enough. I know I sound like a broken record, but it's important to act right now, because these things take time. It takes time to gather the necessary documents for any of these exemptions that you might be applying for, or to enter into a payment plan. It takes time for the applications to be processed and approved or denied. And we really, cannot recommend highly enough that you act immediately, and that you contact us if you need any help to figure out how best to navigate your specific situation. Applications will be accepted until May 19th at midnight, but please do not wait until then to submit. And again, these documents sometimes take time to track down, and consider applying online rather than mailing in copies if you're able, because the turnaround times have been far faster for those virtual applications. Lastly, we have appeals that can be submitted. If you get a denial, you have to appeal pretty quickly within 10 days of receiving the denial. So do not fret if you receive a denial. We can work with you to help figure out how best to file that appeal in hopes that you might get approved. And lastly, I'll just go over some very quick FAQs. So turnaround times are pretty variable, but with the virtual applications, we've been seeing turnarounds of a few days for those that are not trusts. For trust clients, it's been taking a little bit longer, given that that's a newer policy update, and they've recently begun accepting those applications, especially for the Easy Exit, or specifically for the Easy Exit program. There are resources available to folks who don't speak English. There's a fact sheet available on the online website. If you Google New York City lien sale, you'll find a fact sheet that's translated into several languages, and you can also call this number to speak with someone who can meet your language access needs. It's also really critical to note that even if you're disputing one of the charges that you owe, or the arrears, right, that you have, you can still have your lien be sold to the private company and face foreclosure. So just because you're in a dispute process does not mean that you're protected from the upcoming lien sale. And I want to say that that's about it. I might have one last quick slide. Oh yes, important, deed fraud and property documents. This is separate from the lien sale, but just as important. We had some folks ask questions about this last week during part 1. So we've linked the 2 sites that are really great resources to help determine if you've had any activity with regard to your property address and your deed. So please be sure to register for notifications about new documents recorded against your property at this site, and then also check ACRIS, which is a great public records platform that allows you to access your deeds, public documents, etc. And be sure to reach out to an organization if you find that there's been any activity that you don't recognize or that looks off to you. And with that, I will hand it over to Chris. And yeah, of course, feel free to reach out if you need further assistance with any of this. We're happy to answer your questions.
Great. And so maybe before we go on, I see there's no we have no questions in the chat. I might give it a minute or two just to see if anyone has any thoughts. I do want to emphasize sort of, this is such an important matter to address right now. This lien sale is fast approaching. So if, there's a lot of great information that Emily shared, but there's like one takeaway. It's if you think you owe, these taxes, if you received any of these notices, contact one of our organizations as soon as possible so that we can help you navigate the process. It is much better to get off of the lien sale. It's much easier to work with the city on all of these programs. If your tax lien is sold, then it's going to be the company that buys it, they set these special purpose trusts that buy all these liens, and they hire a couple of companies to then work with homeowners, and the terms that they oftentimes offer are pretty onerous. So better to do it now, but it looks like we have some questions. It says, can you repost the last slide for web pages? And can you please repeat the link for deed fraud? So maybe we go back here. Great. And Emily also noted that we're going to circulate the deck afterwards, so you have all these links. All right. So maybe we'll leave that there for a little bit. And again, you'll get the deck afterwards. So you'll have all the websites. Maybe we will see no other questions. We can go to protecting the home. So the part of why this is so important, right? This protecting the home is that it is the most important asset that most people have. Most wealth that is stored in a house. And taking a step back, it's also, this is your home, right? This is going to be a place either where you live or where family members live. So keeping it in the family, keeping the home is important. And even if you look to sell, you want to make sure that you kind of realize all the depreciation in the home that might have accumulated over the years. You have a homeowner who diligently paid their mortgage and accrued all this equity, and you want to make sure that you take every step you can to preserve that equity, and so you could then pass it on to the heirs. And so it is a pretty well established social science fact that most wealth is stored in the home. So you want to make sure that you have that equity preserved for other people. And also, it is critically important, especially now with so many scammers coming, after homeowners in an era of very high interest rates. Too, you have all sorts of companies coming out of the woodwork looking to take advantage of homeowners. And certainly if someone has passed away, that's a time when people are uniquely vulnerable. It might be more at risk for these types of scams. So if you can, maybe move on to the next slide. Great. So after a person passed away, there are a lot of challenges, right? It's a time when you'll be dealing with the estate, right? So it's very stressful. And one of the additional sources of stress is having to deal with the mortgage company when there's a loan. Now, the goal of this presentation is to make sure that people are well equipped with how to deal with it, because there's some very discrete things that you can do after a person's passed away in order to deal with that mortgage company, in order to make sure that the loan is addressed and payments are being made. And so the most common problem that people encounter is that they know that there's a mortgage loan. They know that maybe this homeowner is getting notices. Maybe they just go through the mail and they see that there's a mortgage statement, not sure what to do. And when they reach out to the mortgage company, they are told that they can't talk to the caller because they're not the borrower on the loan. So there are ways that you can address that, and then to get information in order to work something out. Dealing with the Department of Finance when you're not on the deed is challenging. There are lots of people who come to us in the run up to the tax lien sale who are not on the deed, who we've worked with to get them off the lien sale. I would say probably the most important thing right now with the Department of Finance is making sure that if there are unpaid taxes and you get these notices that your lien is going to be sold, to get off that sale. So even if you're not on the deed, you as a family member who passed away, please still reach out to us so that we can help you work through that process. And then we're also going to talk a little bit about sort of what are the options if someone has a reverse mortgage, because the rules are a little bit different if someone has a conventional forward mortgage as compared to a reverse mortgage. So maybe we move on to the next slide. Great. So assessing the situation of heirs. So these are some of the things that we think about, right, when we talk to someone who maybe have a family member who passed away and they're just trying to figure out what to do, with the property. So the first question is, who has an interest in the property? So, this is information that you can figure out in part by looking at publicly filed documents. So one important source of information is going to ACRIS, ACRIS. ACRIS is the city's property registry. That's where all deeds and mortgages are recorded. And it's a good way to see basically the chain of title and who owns the property and then how they own the property. Now, how can title be transferred? So there's a few ways that could happen. A person has a will, it would be transferred according to the will. If a person doesn't have a will, then there's something called administration proceeding, and there's certain defaults in the law as to who the property will pass to. And then sometimes the deed itself will say who has an interest in the property when an owner passes away. So there, another reason to take a look at that deed. So is there a mortgage? And if so, is the mortgage current or in default? The best way to ascertain this is if you're looking at, for example, a person's mail after they pass away, you want to see if they're getting mortgage statements, right? That's a good indication, right? They have a mortgage and tells you who to contact. Are property taxes current or in arrears? I think Emily, covered that. I want to look out for these notices. And then the main question, right, is, what is the goal with the home? Right? Is the goal to take out a mortgage to pay off the arrears? Is the goal to sell the property so that you can realize sort of all that appreciation, have wealth and be able to deploy that wealth in a way that's best for your family? There are financial considerations that come into play that are important to think about. And is there equity in the property? One of the things that we will always do is we can look to see what the property is valued. There are different websites you can do that. Zillow is a common one that people use. Give you a ballpark idea. It's not perfect, but it gives you a sense of whether there's equity. And it's selling an option. And part of this is answering this question depends on who owns the property and how they own the property. So these are all factors that you kind of want to think about and start taking stock of, but you don't have to have all the answers. If you have questions, you can reach out to us, and that's why we're here to help you walk through these. Okay, so next, what is, for bare basics, right? Who are the players right here, right? So you have three different ones, right? So you have the borrower. The borrower is the person, right, who has signed the note. Now, the note is a promise to pay. So if a person buys a house and they take out $500,000, they will sign a promissory note saying that they'll pay off that $500,000 over a certain term, often 30 years. They'll have what the interest rate is. They'll have the principal and interest payment, and then you'll see their signature on the note. Now, that note is secured by a mortgage. A mortgage is a property interest. It says that if you fall behind on the note, then the lender can foreclose on the home and sell it in order to be paid back what they're due. Now, the mortgage will appear in ACRIS because it's a property interest. The note does not. The note, it's a separate document. It's something that the borrower might have, but it's something that you might be able to get from, they oftentimes don't, you might have to get it from the servicer. And then you have the servicer is the second party, so that's the borrower. Borrower is one person who owes money. The servicer is going to be the entity that sends the statements, and then you have the loan owner. Loan owner is the company that has bought the loan, hired the servicer. The servicer is the person that you deal with. These are the Nation Stars, these are Mr. Coopers, these are Wells Fargo, and so on. And so the difference between, like I said, a personal loan and a mortgage is that the mortgage loan is secured by this property interest. And that's why if you default, you're sued in foreclosure, and there could be an auction to basically pay off what's due. And you're also personally liable, right? So if the home in a foreclosure auction, if it sells for an amount that's not sufficient to pay off the loan, then there could be a deficiency. But it's only the person who signs the note that is personally liable. So if you're dealing with a situation where you have a borrower who's passed away, they're not going to be personally liable. So that's an important distinction. Let's turn to the next slide. All right, so the first question is, what do you do, right, with this mortgage company that's the servicer that's sending you statements, right, or sending the decedent statements? So if you call, right, which is people's most, that's their instinct, which is a sensible thing to do, right, see if we could work something out. Almost invariably, that mortgage company, that servicer is going to tell you, we can't talk to you. And there are strict rules that are in place about who the mortgage company can talk to. And the idea is you want to protect, right, the personal information of the borrower. And so the mortgage company will say, well, we don't want to disclose information to people if we don't know that you've been authorized to speak on behalf of the borrower, or if you're a successor interest, which we'll be talking about in a little bit. And so the first thing you want to do is basically confirm your identity with that mortgage company. Again, it is it could be the borrower who could speak to the mortgage company. And so the only other people who could speak to the mortgage company is be someone authorized by the borrower. But when the borrower has passed away, it's going to have to be what we call a successor in interest. And so we talk about what that process is. So next slide. Okay, so this is a rule now that was introduced by the Consumer Financial Protection Bureau. So there's in this area, there are a lot of different laws, and there are a lot of different agencies that promulgate those rules and regulations and enforce them. The relevant ones here are all put out by the Consumer Financial Protection Bureau, which is a federal agency. And they have a whole set of rules about servicing a loan. So again, the servicing loan is when a mortgage company takes payments, processes payments, sends notices to the borrower like mortgage statements, and then works out plans if a borrower falls behind, and we call that loss mitigation. All those rules are in the regulations put forward by the Consumer Financial Protection Bureau. And the one that we're interested in has to do with successor in interest. If you can demonstrate that you are the successor in interest, then the mortgage company is required to speak to you and basically treat you like a borrower. So when you're in this position, the first thing you want to do is make sure that you are confirmed as a successor in interest. So here is how successor interest rules work. So what the federal rules say, it has to be a person who has an interest in the property because of the death of the borrower. And there are a few different ways that you can have or by other operational law. There's a few different ways that this can happen. So like we talked about, if there's a will, right, if a person passes away, then you'll look to the will, and the will establish that you have an interest in the property. If there is no will, then, like we said, there are these default laws. In New York, they call, these are the rules of what they call intestate succession, right? But what it says is that if a person passes away without a will, then the property will transfer to certain relations just by operation of law. And so those people, if you have that relationship to the decedent, you'll be able to demonstrate you have an interest in the property because that person passed away. And then by operation of law, so this talks about the third way that people can get property, title to property in the event someone passes away, which is that sometimes the deed will provide something like survivorship interest. So that would be if a person owns a property with someone else and they have a right of survivorship. That means when one person passes away, the person with right of survivorship has the full interest in the property. And also if you have a married couple that owns a property, by default, it's called a tenancy by the entirety. So when one person passes away, their full interest in the property is transferred to the other person. So you could have a situation where maybe for some reason one of the borrower is, let's say the wife, the husband is on the deed, the wife passes away, but their interest in the property, when the wife passes, they have a full interest. And so they should be able to establish that they're a successor in interest. And then you can also take title to the property as a result of divorce decrees, legal separation, or other property settlement. So these are some of the ways that you can demonstrate your interest in the property. So what you need to do is basically communicate that you are a successor in interest. And there are different ways you can do it. The best way to do it is in writing. And maybe turn to the next slide. What you want to do is send what's called a request for information. And this is just kind of a technical term of art. What it really is just a letter. It's a letter that is addressed to the mortgage company. You have to identify the borrower, right? In this case, the decedent. You have to identify, provide enough information so they can identify the account. And you have to indicate that you're looking to confirm your status as a successor in interest. Now, that letter has to go to a specific address that's maintained by the mortgage company. And if you have the mortgage statement, if you flip it to the second, the back half of it, oftentimes you'll see designated addresses for these letters, these requests for information. And they'll oftentimes abbreviate it, say a QWR, RFI, NOE, qualified written request, notice of error, request for information. That's where the address where you have to send it. You can also go on the website and say, where do I send a qualified written request, right? And it'll be listed there. And if it's not listed in those places, then you can send it to any office, but almost every major mortgage company has a designated office to send it to. And typically in these letters, what you want to do is you want to provide proof, right, that you have an ownership and interest in the property. They'll tell you what other documents they need to provide, but it's better in that first letter to provide that proof so they can confirm you right away. Right, next slide. So the responsibility for the mortgage company when they get this is they have to respond within 5 days to acknowledge that they got your letter. And then within 30 days, they have to either tell you, confirm you as a successor interest, or tell you what documents they need to confirm you as a successor interest. And there's a reasonability requirement here. So, they can't, ask you for dozens of documents, right? They can't say, okay, prove, get us the last 10 deeds, right? They can't make up requirements that are too onerous. They just have to establish that, right, you have this ownership interest. And every mortgage company can define a little bit differently, but for the most part, if you can, for example, produce a deed, produce a will, these are the types of documents that will establish that you are a successor in interest. And they also provide you with contact information if you need further assistance. I would say that generally speaking, always a good idea to send letters. You always want to do this in writing, and we'll get to that in a bit. And so what's reasonable, right? The laws of the state. A lot of these companies are not based in New York States. They may not know, right, why, what are the rules for intestate succession. So when you write this letter, right, a good idea to explain sort of what the rule is, and then to explain how it is that you satisfy that rule and why it is that you have an ownership interest. the specific situation, the potential successor in interest, good to communicate that information. Why is it that you're reaching out to them? Documents which are already in the possession of the servicer. Obviously another big one is want to provide the death certificate. That's something that they don't have. But these are the types of documents you want to submit. If they need anything else, they'll have to let you know within 30 days, and they have to promptly make a determination whether you're a successor in interest. Now, that's particularly important. If there's any reason why you need that confirmation right away, include that in the letter, because that will affect the analysis of what is meant by prompt. There's no real deadline there, right? No date. You have to acknowledge the letter within 5 days, but it doesn't say what number of days would constitute a prompt response. It's a facts and circumstances test. So explain why it is that you need to be confirmed right away. And these are some of the documents: the deed, right, showing the survivorship interest, a will, an affidavit heirship. That could be just an affidavit that you are attesting sort of your interest, your relationship, divorce decree, and then obviously if you're claiming an interest from a parent, right, then you want to establish your relationship with that person. That could be in the form of like a birth certificate plus the deed from the parent. So those are some of the things to think about. And what I'll say is that there's a lot of information here about what are the intestacy rules and the like. This is why we are here, right? We are here to know these rules, to help you draft these letters. We do this all the time. So reach out to us and we can make sure that the letter says everything, includes everything it needs to include. So now why is it relevant, right? Once you're confirmed as a successor interest, why is this an important moment? Because then they have to treat you the same as a borrower. That means that they have to communicate with you, which is important. That's a really good time. I always tell my clients, once you get confirmed as successor interest, the next thing you have to do is send another letter, same request for information, and say, give me a copy of the servicing file, right? Give me a copy of that note. There's a number of other documents you can ask for, and they'll have to provide it to you within 30 days. And then you'll have this complete picture of what's happening in the loan, get a sense of what they owe, what kind of communications they have with the mortgage company, if they're in default, were they working on a loan modification. You can get all that information, but only after you're confirmed as a successor in interest. And you can also are treated as a borrower for purposes of applying for a loan modification. Now, an important caveat is that just because you're confirmed as a successor interest does not mean that you're assuming, right, the debt. What does that mean? Assuming the debt means you're stepping into the shoes of the borrower, right? And that's important because if you assume a debt and step into the shoes of the borrower, then you are personally liable, right? So that's something you don't want to do until, right, you have at first an understanding of what's due, right? And generally speaking, you only want to assume a loan if you're also simultaneously modifying it, right? No one wants to assume a delinquent debt. There's no reason to do that, right? You want to make sure that if you're assuming any loan, that it's part of a modification agreement. So all you're doing here is you're basically a borrower for the purposes of communicating with the mortgage company. They can communicate with you and you can send documents to them and they have to respond to it. All right, next slide. Now, what happens if they don't respond, right? Now, this is why I would say, if you're trying to be confirmed as successor interest, don't call, send these letters, right? If they don't respond, reach out to us. I would say as soon as you can, reach out to us because we can help prepare this letter in the first instance and make sure that you have all the documents you need to confirm yourself as successor interest. But in the event that they don't, you can escalate with the servicer, right? You can call them and say, hey, I never got a response here. I think there's no harm in doing that. But what you really want to do is send a second letter to them, and that's a notice of error. And that letter is something that you send to the mortgage company to that same address. You have to identify the borrower, identify the account, explain that there's an error in the account, and that they need to fix it. And the error here is that they haven't confirmed you as a successor in interest when they should, and the way to fix it is to confirm you as a successor in interest. Same rules apply in timeline. They have to respond in 5 days and correct the error within 30 days. The reason why you want to send that notice of error and you want to send the written request for information is that if they don't follow the federal rules, you can sue them, right? Now, you may not actually sue them, right? But the threat of a lawsuit, right, gets a company to act a lot faster. So that's why, and when they get those letters, the request for information goes to this designated address, they know that they have to take this a little bit more seriously. So send the request for information, send the notice of error, and you can also contact Fannie Mae or Freddie Mac. There are ways of looking that up to see if the loan is a Fannie Mae or Freddie Mac loan. You can contact them. If it's an FHA loan, you'll see it's on the mortgage. You'll say it's FHA. You can contact FHA. If this is in settlement conferences, right? All our organizations represent people in settlement conferences. That's after your student foreclosure. They schedule these conferences to negotiate something of a workout, like a loan modification. Sort of in those settlement conferences, they have to negotiate in good faith. If they're not confirming a successor in interest, that's not a good faith negotiation. But again, reach out to us. And then you can file complaints. And these are some of the agencies. I would say file complaints with all of them, but I will tell you, I was actually just recently at the Consumer Financial Protection Bureau. Unfortunately, that bureau is not able to respond to consumers and effectively enforce the regulations as they once did. So file it because it gets part of a database. But in terms of actually getting a response, I think you want to do most of your follow-up with Department of Financial Services and the Attorney General's office. But again, main takeaway, if you're in this position, if borrowers passed away, don't know what to do, reach out to legal services, they'll help you prepare these letters, make sure you get confirmed successor interest, and talk to you about next steps.
Thank you. Thanks, Chris. I think let's pause for a moment and see if there are any questions in the chat that relates to the information that Chris just provided, and then we'll move on to reverse mortgages.
Yes, we have several questions in the chat. I'm happy to read them out if that works, and Chris, and feel free to jump in. So I'm seeing here from Rizal, I apologize if I'm not pronouncing that correctly. They said, my mortgage company is paying property tax every quarter, but there is $20 outstanding for the last few years. Will it create an issue in the future?
Yeah, I mean, that's puzzling why they're not paying the full amount. So if you go on the Department of Finance's website, right, if you look at the property taxes or reading the statements, it's saying that the $20 are still outstanding. I think it'd be pretty unlikely that you're going to run into any trouble for $20, but they should fix it. And that's a good example of using a notice of error. You can write a letter to the mortgage company saying there's an error in your account because there are $20 that are outstanding that they haven't paid, and that has to get paid out of the escrow. So I would say get ahead of it. You can draft that letter. If you have questions on how to do it, we can tell you how to. But yeah, have them fixed, have them pay it. There's no reason why, if you have an escrow, that your property taxes or any portion of them should go unpaid.
Great, thank you. We have a question from Francesca who says, she asked, can you become a successor in interest when the deceased previously had a reverse mortgage?
So these apply to forward mortgages, is the rule. So we're going to talk about reverse mortgages in a little bit. Deanna is going to talk about that.
Wonderful. And Beverly asked, what is the tenant's right when the owner died with no will and no heirs?
So if you have a lease, you still have the protection of that lease. At some point, if there are no heirs, and if there is a mortgage, right, they're gonna the mortgage companies to start a foreclosure case, but you're not required to leave if they start a foreclosure case, and you'll get notices to that effect. Basically, you can remain. But then at the conclusion of the foreclosure case, if there really is no one there, right, the owner died, there's no heirs, no will, no one's, prosecuting the case, what's probably going to happen is that the foreclosure case is going to move pretty quickly. They'll get a default judgment. They're going to be able to schedule a foreclosure auction. They'll sell that house to a new buyer, and the new buyer would have to start basically an eviction proceeding, or you might be able to work something out with them.
Great, thank you. And I just wanted to note, I'm seeing Sharon's question. I apologize, Sharon, for having missed this earlier. It looks like this was addressed to us at Brooklyn A. It says that since New York won the suit against Countrywide, are you entitled to any reimbursement? I transparently don't know the answer to that. So if other folks on the call if other panelists or hosts know the answer to that, feel free to jump in. And otherwise, you should absolutely send me an email. I shared my email further down in the chat, or reach out to any of us. Our contact info is listed at the end of the presentation, and we can look into that further for you.
I can just quickly answer. So Countrywide, which was put out of business a number of years ago, there was settlements and funds, but there's no funds available for like individual homeowners. So yeah, nothing from that lawsuit. But like we said, with all these devices we talked about, the request for information, notice of error, you can bring lawsuits. And if they don't fix it, not only get them to fix it, but also pay your fees. So another reason to use it, send those letters.
Excellent. Thank you so much, Chris. And I just wanted to note briefly, Yvette, I know I responded to you, but if other folks are interested in getting that slideshow from part 1 last week, we're very happy to circulate that again. But unfortunately, I don't think we'll be circulating the recording at this time. But Dion, feel free to correct me if I'm wrong.
No, I'm not correcting you. We're not circulating the
Okay.
recordings yet. With too many agencies.
Absolutely.
So I'm going to go into reverse mortgage. If we're ready, Emily, is that it with that? Great.
That's all for now. Thanks.
Thank you. So, I do elder abuse prevention. So my first line is no one is entitled to an inheritance, right? However, you want to protect your home and you want to keep your home. And there are certain instances where the best option for you is a reverse mortgage. And so reverse mortgage, a lot of people believe because there's just a lot of information about it, and maybe just the name itself sounds confusing, but a lot of people believe that they are losing their home when they take out a reverse mortgage. But remember, when you take out a reverse mortgage, the deed has to remain in the homeowner's name. So you're keeping your home. You still have your home. Now, most of these are FHA insured, home equity conversion mortgages, and we always call them just HECM mortgages. And that's all it means. It's just that they're FHA insured, the majority of them. And the borrower must be 62 years of age or older. Now, before, what used to happen, and it still happens, like these are one of the mortgages that it's not a forward mortgage. It's not one that you're paying on. You're actually taking the equity from your home in this. So it works and that's why they call it a reverse mortgage, right? And years ago, what used to happen when they first came out is, of course, the older you are, the more money you may qualify for, right? So what would happen is you would have Chris, who was 92, and Chris would be married to Emily, and Emily is 25. And what would happen is they would take Emily off of the deed, even though Chris and Emily owned it. They would take Emily off of the deed because Chris would get more money from the reverse mortgage. You take out more money. What happens though, and I'm not killing you, Chris, but what happens if Chris passes away? If Chris passes away, Emily now has no protection because she's no longer on the deed. So they stop that. Now they've made it so that you can keep the younger borrower on it. It may still affect the amount of money you get, but at least that younger borrower is protected, right? You must live in the home as your primary residence, right? One of the good things is sometimes you're having problems paying your bills, going through, and if you had a forward mortgage, your income, because unfortunately, as you get older and your income doesn't increase with your age, right? And so your monthly payments may get higher and you can't pay it. With the reverse mortgage now, you don't have monthly payments to pay. Your proceeds, you can take it as a lump sum, monthly payments, line of credit, or a combination of these. Remember, you're taking from the equity from your home. You're not actually paying to own your home. It can be used to pay off, of course, a prior mortgage loan, tax liens, fund home repairs, or supplement retirement or your fixed income. Now, with the new HUD rules, there's some new HUD rules in effect, and one of them requires financial assessment. It looks at a person's income and credit. Before, they didn't look at that, right? Because even though you have a reverse mortgage, you're still responsible to pay your taxes, homeowners insurance, and water and sewer charges, right? And what happened was many people who had reverse mortgages were winding up having tax lien sales or other sales because they had fallen behind, because their income was not enough to pay the taxes, or you know what? Sometimes you're just not good at paying your bills. Sometimes some people need a little help paying their bills. Like, for instance, you give me a lot of money, give me $1,000, I may go buy some shoes instead of paying my Con Ed bill. These things happen. What they did was they did a LISA, which is a lifetime expectancy set-aside account for people who don't have quite as good credit or were in foreclosure. They're kind of making sure that you're able to pay going forward your property taxes, homeowners insurance, and water and sewer. So the reverse mortgage company servicer will pay that for you, right? So your initial principal balance that you get is based on your appraised value of the home, the interest rate, and again, it is going to look at Emily. It's going to look at the age of the youngest borrower, including the non-borrowing younger spouse, if there is a spouse that's not on it. It's a non-recourse loan, which means that if something happens to the borrower, you don't have now, they can't come after. Let's say Emily was not on the deed, right? And Chris passed away. I keep on killing poor Chris. But if Chris passed away, Emily would not be responsible for that loan. And we'll talk about it a little bit more. What Emily will have to do is probably take out a forward loan or sell the home to do that. Essentially, the heirs of the estate do not owe the debt. It's extinguished when the last borrower passed away, but the lender is still going to get their money, right? So they can still foreclose on the property. So non-borrowing spouse, and again, we had talked about that. We just want to protect them, right? So you want to protect them against displacement. That was the whole purpose of the Heckman program to begin with, right? It was to keep senior citizens or older adults in their homes, right? That was the congressional intent behind it. So HUD now doesn't insure a mortgage unless the homeowner is protected from displacement until death or sale of the property. And by homeowner, we're talking about that includes the spouse of the homeowner. So if the non-borrowing spouse has to be able to show the marriage certificate that they were married at the time of the loan, home is their primary residence, and a legal interest in the property, and they have to cure the default that's out there. Again, this is a non-borrowing spouse that was not on the deed, right? Or was not a part of the reverse mortgage. So suppose you have other heirs rather than the spouse, right? Suppose it's not Emily, but let's just say Chris had children. And Heckman, with a mortgage, they want the heirs to decide or sell or keep the house within 30 days. Now, many of us know after the death of a loved one, 30 days goes by so quickly. You don't have time to even come to terms with the death. So what you have to do, you still have to notify them of the death, but the lender may approve up to a 90-day extension, and it can go up to about a year. We've had cases where they've extended it up to a year, right? But as an heir, you have to, yes, they're going to give you some time to grieve, some time to work out, but you have to show that you're actively working on the estate. Remember, though, one of the things you have to remember is that, yes, the bank is going to give you an extension, but that interest is growing and it's compound interest. So, suppose again, we're still talking about heirs other than the spouse. If you're handling the estate, you have to go through probate, or if you died intestacy, that can be a slow process, right? And again, as Chris had mentioned in his presentation, lenders don't deal with unauthorized representatives. So again, if you're planning on doing a reverse mortgage, it may be a good time for you to make sure you set up that you have a will, set up that you have someone so you know who the future heirs are going to be ahead of time, so they can just go in and the process will go quicker and more smooth. So let's say, what do you do if the borrower passes away? And I'm no longer going to use Chris. I'm going to use Arnold, right? Because that was my daddy passed. Will that, because I feel so guilty bothering poor Chris. So here we go. So you have a house that's worth more than the mortgage balance, right? Oh, so it's above water. So you have two options. You can sell the house for the market value, right? So then what would happen is the reverse mortgage company will receive 100% of the debt that they owe, right? So you're paying off that debt, but then the heir, you will get the remainder of what's left after the sale, right? Does that make sense? Then let's just say I don't want to sell this home. A lot of times a home is that is something that a lot of us use as it is our inheritance. This is how we pass down from generation to generation, right? So if you want to keep your home, then what you want to do is you want to take out a forward mortgage in order to pay off the reverse mortgage, right? And if that's the case, then you have to pay the reverse mortgage in full. Now you get a little break if your home is underwater. Then if your home is underwater, which is not necessarily good, right? So that means the value of your home is lower than the market value, right? So what happens is the reverse mortgage company is going to receive 95% of that market value that it is now. If it's underwater, and the insurance is going to cover the rest, right? Again, the estate is not responsible for the remainder because it's a non-recourse loan. They can't go after the estate for it, right? And again, if it's underwater and you want to keep the home because look, this is where I've spent most of my life. This is where I want my family to live. Then you can take out again a mortgage, right? And the new mortgage, you have to pay 95% of the market value. And again, you're not responsible for the remainder interest, right? So these are just some quick takeaways. Remember, don't get bullied into making a rash decision or action. Think about it. Ask for an extension of time. Don't make a decision the week after your loved one has passed. Take a little time and think about it. You can get that time, right? You can do a short sale. You can do selling of other estate assets. Take your time and figure it out, right? If it's probate you have to go through, or intestacy, let the reverse mortgage company or servicer know that I have started these. As Chris said, communication is key. Let them know who you are. Let them know that this is what you're doing. You are maybe the executor or the administratrix of the estate, or you're one of the heirs. Let them know that you need that 90-day extension. And again, a lot of times you may decide to sell the home, but especially where our homes are located now, keeping the home may be a good idea and a good asset. I think that's it for me. I'm going to stop well, let me go. First, I'm going to do this. Thank you for tuning in. This is who we are. So you have the Queens Coalition. I want to, because I'm going to stop talking, I want to, of course, thank Chris because he's amazing as always. And then, of course, Emily is wonderful. If you have tax questions, please talk to her. Next week is the 20th, so we really can't emphasize that more. I'm going to stop sharing and open it up for questions and answers.
Wonderful. Thank you so much, Dion. I'm seeing one question here in the Q&A chat for Chris. It asks, what is the process for a real estate LLC to impose themselves on your deed by defrauding an heir? How does the Department of Finance release info to LLCs, which enables this process to get started?
There's a lot there. What I'll say is this: if there is a circumstance where you have potential deed theft, right? And what we look out for is certainly if you see these LLCs, right, that just pop up, might be on Acris, might be elsewhere. That's a circumstance where you really want to reach out to like legal services. These are cases that we take. I think most of our offices have cases involving deed theft. So I would say the best thing to do is to reach out to us so we can kind of assess, what is going on, what happened, and sort of how you can protect your interest in the property. Unfortunately, it happens a lot. People who are vulnerable, right, oftentimes fall prey to these scams, right? And so if we're talking about particularly, elderly homeowners, right, it's just ripe for abuse. So certainly reach out to us if you have any cases potentially involving deed theft. But whoever asked that question definitely knows what to keep an eye out for, which is these almost invariably the companies that buy are involved in these deed thefts are going to be an LLC. These are limited liability companies, but also they could hide, right, who's behind the transaction. Oftentimes there's an LLC that is owned by an LLC that is owned by an LLC. So it gets very complicated, but that's why we're here.
Yeah, and one of the things with that too is we find that now they're trying to do commercial foreclosure, right? Because it's an LLC now. So we really have to be careful with that. So anytime anything like that happens, please see one of our agencies.
Thank you both so much for that. I'm seeing a question from Kimberly asking, what does actively working on the estate mean?
So what you're trying to do is actively work on settling the estate. So you're going to, if you have a will, you're going to surrogates court and you're getting that will probated. If they died intestate without a will, then what you may want to do is do an heirship affidavit to show your entitlement to being the successor in interest of the next person who can take over either the mortgage or the reverse mortgage, who can pay off the reverse mortgage.
Wonderful. Thank you so much. I also just wanted to, I'm seeing a lot of questions from folks about contact info, getting slides from part 1 and part 2. And I'm wondering, Dion, if it's possible for us to send parts 1 and 2 to all the folks registered for both parts. Is that something we can do?
I think that is entirely
Amazing.
possible, Emily, and that's what we'll do. If you registered, we should have your information, and we'll make sure that you get parts 1 and 2. Again, you're not going to get the video, but you will get the slides.
Wonderful, thank you. And as far as our contact info goes, those are on the slides, on those yellow slides in the PowerPoints in both parts 1 and 2. So you can absolutely get our contact info from the slides. And Bernice, I'm seeing a question in the chat that says, do you have estate attorneys that can assist in setting up wills? I want to divide my property to my family, ensuring that they can sell it off.
So I know Legal Aid actually has our part 1, we actually had the attorney on who actually does the wills. So you will get, once we send you the slides, you'll see all her contact information there.
It's Casey.
Casey, yes. Casey Lee.